Your Honor, this is Mr. Valentine, whose matters I believe are at the end of the calendar, numbers 26, 27, and he has declined counsel and would like to proceed on his own. I believe
So
my office had been this matter before.
Yeah, Mr. Valentine, you had an attorney appointed and then you didn't come back the way we needed to come back way back in March. So you got an attorney sitting there, an experienced criminal defense attorney might help you. Would you like to take the advantage of having Thurston County Public Defense represent you again?
No, ma'am.
Can you tell me why?
Because I would like to proceed sui juris, because I believe I have my best interests, and I don't think anyone else in this court has my best interests for me.
The speaker argues that representing yourself in a serious criminal case can be a risky decision, especially when the possibility of losing your freedom is involved. To make the point, they use an example comparing it to a life or death situation where most people would choose a trained professional over trying to handle everything themselves. The comparison is meant to highlight that while independence is valuable in everyday situations, there are certain areas where experience and expertise matter far more. Just as people generally rely on qualified professionals for highly technical or high-stakes tasks, the speaker believes legal representation in court often falls into that same category. The overall message is that criminal trials can involve complicated procedures, legal strategy, and serious consequences, making professional legal guidance extremely important for many defendants.
Okay. All right. Well, first, there are a couple of warrants. I'm going to turn to the prosecuting attorney, Mr. Abid, first, and see what their recommendation is on this warrant return, and then I'll turn to you. So I'll just allow you to represent yourself today as you want to. Mr. Abid?
Your Honor, the state would object to releasing Mr. Valentine, and the alternative, the state asks that the court set substantial bail on both of these matters. The first one, ending in the cause number 693, is a case, is an old case. Mr. Valentine, I'm seeing, has substantial failure to appear history. This is here's sorry, Your Honor. Mr. Valentine was on warrant status for a significant period of time. In March, the court issued a $15,000 warrant on each case. The court, Your Honor, or the state, Your Honor, asks that the court impose bail in the same amount as the warrants.
And this is first DUI from November of 2021, and then the second allegation, January of 2024.
Correct. And
were these, one, it appears, was an allegation of a breath sample of 0.14, and the other from 2024, do you know the allegation?
My notes show that the 2024 allegation was included a refusal.
Okay. All right. So, Mr. Valentine, what the state's asking me to do is have you post about $30,000 cash or a bond bail, and consider those same restrictions that were on you before, that you show up at pretrial services, that you stay clean and sober, you stay law-abiding, you give UAs, you be on a device that's attached to your person to make sure you're not consuming alcohol. What do you have to say?
I object to that, Your Honor. I did make my best effort to show up at court, even when I didn't show up, because I was confused about the dates. The clerk told me the wrong date. I showed up. I gave the clerk a letter. I wrote a letter to the court, and I also wrote counterclaims and responses to the State Attorney General's office, and I got no response from either. I went to try to squash the warrant. They told me that they wouldn't squash the warrant. They wanted me to either turn myself in, or they wanted to get me to pay more bonds. I have absolutely no problem showing up and representing myself. As far as what was the next thing? As far as these charges that are against me, I wanted to be clear that I am not a person. I'm not a legal entity. I'm a living man, and I want to enforce my constitutional rights. I have the right to drive without a license. I don't need a license. The Supreme Court has proven that many times. And it is also my understanding that this is a Nisi Prius court, and I would like to implement Rule Nisi. If the prosecutor has a valid contract between us, I would like him to produce it. If not, I do not wish to contract with any members of this court.
The Speaker argues that by choosing to drive on public roads, individuals agree to follow the laws and regulations that govern those roads, including laws relating to impaired driving. The point being made is that participation in public systems comes with legal responsibilities and consequences. The discussion then shifts to the defendant's use of the legal term nisi prius. The Speaker explains that the term refers to a trial court, or a court of original jurisdiction, where cases are first heard before any appeal takes place. In other words, it describes a lower court handling the initial proceedings rather than an appellate court reviewing decisions afterward. The criticism here is that the defendant appeared to use complex legal terminology in a way that sounded authoritative but did not meaningfully change the legal issues being discussed in court.
Well, Mr. Valentine, I'm going to hold you on 15,000 cash or bond bail on each of these independently. So you'd have to post bond to be released, as I find that you're a risk to reoffend and a risk to commit, another DUI or vehicular assault or homicide, given the history while under the influence. So you're a danger to the community is what I'm finding. And you don't come back when we order you to come back, and you don't comply with court orders. So 15,000 cash or bond has to be posted on each one of these separately. And then you have to get yourself into pretrial services within 48 hours of release and have a scram device attached, stay clean and sober, stay law abiding, in order to stay out of custody. No alcohol, no marijuana, no non-prescribed drugs, no bars or taverns, and don't drive unless you have a good license and proof of insurance. I'm going to set another court date. We would do this.
What jurisdiction is this court operating under, Your Honor?
Thurston County District Court here in the state of Washington.
Or what jurisdiction are you trialing me under?
What jurisdiction? Thurston County District Court, Thurston County, state of Washington.
That's not what, is this under a common law jurisdiction?
I'll have you research all that yourself, sir. I'm not going to argue with you. I have jurisdiction over you and over this matter.
So is this court operating common law, ma'am?
I'm talking to my clerk. 1 second. And make it clear, good, that he's proceeding pro se and that we need to do.
I am not pro se. I'm a series jurist.
All right. You're proceeding without an attorney.
Did you take an oath to uphold the Constitution of the United States, ma'am? The supreme law of the
I
land?
sure did. I take it every time I get reelected, and I take it very seriously.
Will you be honoring that?
Very seriously.
Are you going to be honoring that?
No, it's just free trial, and then we'll get it set for confirmation and jury dates.
Are you honoring that oath today, ma'am?
I sure am. And I do it every day.
So you think I'm a person?
I sure do.
So you think I can be bought and sold and regulated? You think I'm a persona, that I live in the likeness of another?
The Speaker responds by pointing out that court orders do not depend on a defendant's personal consent in order to be enforced. In other words, once a court has lawful authority and jurisdiction over a case, its rulings remain binding regardless of whether the defendant agrees with them. The exchange reflects a common argument often seen in sovereign citizen-style cases, where individuals claim they can reject or refuse the authority of the court. Judges typically reject those arguments, emphasizing that legal obligations and court decisions are not optional based on personal agreement.
I think you're a human being and you're covered by the laws of the state of Washington.
A human being and a person are two different things.
No, I'm not interested in semantics. So
I'm trying to get down to
you can define things the way you want, but the law is not agreeing with you. All right, we're going to be back on September 20th, 1:30. We'll probably talk some more about your decision to represent yourself, and that's fine. But don't be surprised if whichever judge is there has another discussion with you about that. And
Can
at
we
any
change-
time, at
change the
any
venue
time, anytime you can ask the court to appoint an attorney. Anytime you can hire an attorney to represent you too. You're not prevented from that.
Everyone, an attorney.
So
change
we'll
it?
be back on September 20th, and you need to be back in court. If you're still in custody, we'll hear you in custody.
Can we
And
change
if
the
you
venue?
do postpone, you have an obligation to get into pretrial services within 48 hours and comply with them for sobriety monitoring. And that substance use monitoring program will pay for the Scram device.
Can we change the venue, ma'am, for lack of jurisdiction?
Well, you'll have to file all your motions in writing, and then you serve them as well on the prosecuting attorney, and then we'll set motion hearings.
I don't have the resources to do that in custody, ma'am.
I think you do.
I don't. There's not much paper here. There's no computers I can use, no printers. They're not giving me post stamps.
Offering you Thurston County Public Defense's assistance, I could.
Deny the right to defend myself. You want me to hire someone else to do it? I'm a
I'm
sound
not
mind and body.
denying that, and I'm not going to argue with you, sir. So, at any time, we can talk about standby counsel and talk about counsel.
Everyone represented. I will continue to proceed sui juris.
All right, that's up to you. All right, so we're done today, and those orders will be given to you in the jail.
All right, I don't consent to any of those orders.
The judge is pushing back on the defendant's wording, focusing on how legal terms are being used in court. In particular, the reference to "we the people" is being questioned because it is being used in a way that doesn't match its legal or constitutional meaning. The judge is highlighting a common issue in these types of arguments, the mixing of everyday language with legal concepts in a way that can create confusion but doesn't actually change how the court recognizes a person's status or obligations. In legal proceedings, a defendant is treated as an individual before the court, regardless of how they choose to describe themselves.
And folks, I'm guessing you're all here for the same case, since you're all sitting shoulder to shoulder. What case are you here for? Okay. And Ms. Moore, is Mr. Valentine, is that Mr. Valentine with you by chance?
Yes, it is.
This is Mr. Valentine,
Okay.
Your Honor, wishes to proceed without counsel.
Okay.
First of all,
Yeah,
would like
hold on. I'll let you know when I need to hear from you.
okay.
So Ms. Moore, has your office appointed somebody to replace Mr. Gaslin?
Your Honor, we were not appointed at the last hearing, and I'm not asking for appointment today as Mr. Valentine is declining representation. I have
Okay,
advised.
well, okay,
He wants
I'll take care of it. Thank you. Mr. Valentine, as Ms. Moore has indicated, you've told her you want to represent yourself. I'll tell you that's a huge mistake. I will treat you like you graduated from law school. I'm going to guess that because you're sitting there next to Ms. Moore, you have not graduated from law school, but you will be treated as if you had, which means I will expect you to know everything that I expect every lawyer to know. I will expect you to do the things that I expect every lawyer to do. I will expect you not to do any of the things that a lawyer is expected not to do. All that means that you haven't been trained in those areas, and yet I'm going to hold you to those standards. You would be making a bad mistake if you represent yourself, particularly because with two cases like this, you're probably looking at potentially up to 2 years in jail. So it's really important that you have good representation. If you were there, even if you had been trained as an attorney, I would say do not represent yourself. Lawyers know not to represent themselves. And there's a saying among lawyers that if you ever get charged with a crime, lawyers will say, it's a fool who represents himself. That is, even though they're trained to do that. So I would strongly recommend you not do that. You have the right to do it. I'll be very clear. I think you would be making a huge mistake should you do that. Do you have any questions about that? Do you have any questions about that?
Are you attempting to intimidate me under the color of law?
The speaker summarizes what happens next in the case, noting that the intervening hearing was not publicly broadcast but appears to have followed a similar pattern to earlier proceedings. According to the narration, the court continued to reject the defendant's motions and did not allow arguments based on sovereign citizen-style legal theories to proceed on the record. The judge's approach is presented as firm and focused on keeping the proceedings within established legal procedure. The video then moves forward to the next available hearing, where the case continues under the court's standard process.
Do you have any questions for me?
That was
Other
the
than that,
question.
no, I'm not in tempt. I'm trying to make it very clear to you that I think it's a big mistake.
I'm ready to proceed.
Okay. All right.
First of all, I would like to address we the people, and I would ask that they would all stand for a moment.
No,
We the people of
just
special appearance.
So he has already received the discovery material in the case, which is why the argument being raised doesn't appear to be about missing evidence. The question from the court's perspective is what specific issue is still being challenged or disputed at this stage.